time with Salat ala Muhammad wa al Muhammad.
Yeah, I'm going to keep the coat. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. وإن طائفتان من المؤمنين اقتتلوا فأصلحوا بينهما، فإن بغت إحداهما على الأخرى فقاتلوا التي تبغي حتى تفيء إلى أمر الله، فإن فاءت فأصلحوا بينهما بالعدل وأقسطوا، إن الله يحب المقسطين. إنما المؤمنون إخوة فأصلحوا بين أخويكم واتقوا الله لعلكم ترحمون. يا أيها الذين آمنوا لا يسخر قوم من قوم عسى أن يكونوا خيرا منهم ولا نساء من نساء عسى أن يكن خيرا منهن، ولا تلمزوا أنفسكم ولا تنابزوا بالألقاب، بئس الاسم فسوق بعد الإيمان، ومن لم يتب فأولئك هم الظالمون. يا أيها الذين آمنوا اجتنبوا كثيرا من الظن إن بعض الظن إثم، ولا تحسسوا ولا يغتب بعضكم بعضا، أيحب أحدكم أن يأكل لحم أخيه ميتا فكرهتموه، واتقوا الله إن الله تواب رحيم. يا أيها الناس إنا خلقناكم من ذكر وأنثى وجعلناكم شعوبا وقبائل لتعارفوا، إن أكرمكم عند الله أتقاكم، إن الله عليم خبير. قالت الأعراب آمنا، قل لم تؤمنوا ولكن قولوا أسلمنا ولما يدخل الإيمان في قلوبكم، وإن تطيعوا الله ورسوله لا يلتكم من أعمالكم شيئا، إن الله غفور رحيم. إنما المؤمنون الذين آمنوا بالله ورسوله ثم لم يرتابوا وجاهدوا بأموالهم وأنفسهم في سبيل الله، أولئك هم الصادقون. قل أتعلمون الله بدينكم والله يعلم ما في السماوات وما في الأرض، والله بكل شيء عليم. يمنون عليك أن أسلموا، قل لا تمنوا علي إسلامكم، بل الله يمن عليكم أن هداكم للإيمان إن كنتم صادقين. إن الله يعلم غيب السماوات والأرض، والله بصير بما تعملون. صدق الله العلي العظيم.
Today we are very fortunate to have Zahra Al Rikabi, who will be speaking to us on the topic of mediation, a means of transforming conflict. Let's welcome her with Salat ala Muhammad wa al Muhammad. Zahra is a barrister at Brick Court Chambers, focusing on commercial litigation, public international law, public law, and human rights. She has a broad practice and is recognized as a leading junior for both public law and EU law by Legal 500, and is frequently instructed in high-profile cases in her areas of practice. She's appeared as sole counsel in the High Court and Court of Appeal. She's also been led in cases before the Supreme Court and the Court of Justice of the EU. She's a native Arabic speaker, which makes her well placed. Okay, right. As-salaat ala Muhammad wa ala Muhammad.
Assalamu alaikum. Thank you very much for missing the Argentina game to be here. I appreciate it. I understand it's a big sacrifice as well, and wouldn't be offended actually if anyone announces goals as they happen. But so I came here to speak about mediation because it's a topic I'm very passionate about, and in fact it's a topic I'm very passionate about because I've been a litigator for 10 years. So I know what it's like to fight disputes and the impact that has on the claimants and the defendants and the witnesses and everybody else, and the huge amount of costs involved and the inability really of the legal process to meet all of the needs that people think it will meet. So I wanted to come here to explain a little bit more about what mediation is, why mediation is a good dispute resolution mechanism. But before I get into that, I think what really helps to set the ground for that is to understand what's going on in a dispute, in a broader dispute. So putting aside legal disputes, what's going on when we're in conflict and what helps to resolve a conflict. And then we can transpose that to legal context and think about why litigation isn't necessarily the best way to go about things. So my starting point is that the word conflict is normally very loaded and we assume it to be a negative thing. We assume that conflict is a negative thing. And what I'd like to propose is that actually conflict is necessary to relationship, that conflict is necessary to business, that conflict is necessary to community, that conflict is actually not inherently negative. And I've got here a model that I found in a book called Caring Enough to Confront, which is a really interesting book. And the author, David Augsburger, has set up this sort of matrix that captures it quite nicely, I think. So on one hand, he's got high concern for relationship as a meaningful goal. And then on another, high concern for goals. So high concern for goals is your individual goals, your individual interests, your individual aspirations. And high concern for relationship is self-explanatory. When you have low concern for relationship, when there's a conflict and there's a clash with your personal goals, you just walk away. So there is no need for conflict because you just remove yourself from the situation. If you have little concern for personal goals and there's a conflict in the relationship, you put the relationship first. And so, again, you don't need a conflict. You don't need to work out to resolve the conflict because you put the relationship above yourself. And we know how that goes. You know, the resentment builds up and at some point it all implodes. So what he puts forward in his book is that it's possible to have high concern for goals and high concern for relationship. But what you need in that little top right-hand corner is I can care and confront. You need to be skilled at confronting in a way that doesn't damage the relationship. How do you bring those issues to the relationship and still have a concern for care and a concern for your own personal goals? There's a definition of conflict in Mediators Beyond Borders. It's a book I've got that I really genuinely love, and I wanted to share it with you. Conflict is an opportunity and a request for authenticity, acknowledgement, intimacy, empathy, understanding, growth, or learning. In other words, a request for a better relationship. So I think if we start seeing conflict as somebody saying, I would like to have a better relationship with you, we might approach it very differently. And then, you know, that dreaded, we need to talk conversation becomes perhaps less dreaded when if you heard it as, not as criticism or as something negative, but as a request for a better relationship, then perhaps we could begin to approach it differently. So with that starting point, I mean, why does conflict fill us with so much dread? And why do we end up trying to avoid it or dealing with it so terribly? I think it's because as a society, and regardless of cultural background, we're not trained in conflict resolution. We're not brought up to deal with things head on, and we don't have the skills to be able to resolve a conflict in a way that says, I disagree with you and I care. I still care about you. And I just wanted to introduce very briefly, I mean, this needs a talk in itself, but I wanted to introduce very briefly the concept of nonviolent communication by Marshall Rosenberg. Some of you may have come across it before. But it's a 4-step process, and you don't necessarily need to follow it in that sort of quite rigid way. It's normally taught in that rigid way, just so you've got the tools. And then once the tools are entrenched, you can think about applying them differently. But if you think about the sorts of conflict conversations that go terribly, they normally start with, you did something terrible, I therefore feel terrible, and it's your fault, and I demand you fix it by doing X. And the you did something terrible piece is judgmental. There's a judgment inherent in that. And so the response is immediately a defensive one. It's no, hang on. And then you get stuck in that attack and defense phase. Whereas what MVC tries to encourage is simply an observation. I'll use a domestic example for this. If you say to someone, gosh, you're always so lazy, judgment. If you say, oh, for the third time, the dishes have remained in the sink. That's just an observation. It might be that you've had a pattern of conflict that has gone on for so long that they hear the judgment without you actually using judgmental language. But actually, you're just making an observation. When I come home and the dishes are still in the sink, just pure observation. Then you get into feelings. You can talk about how you feel without saying that the other person made you feel something. You just say, I feel this, whatever it is. And then I think here's the key aspect of MBC, where the real magic happens, is this language of needs. What we normally do when we talk to people, when we have conversations about people, is we try to externalize the whole thing so that it's a lot less vulnerable. So you say, oh, there's an external rule of decency that you have broken, and I can just tell you in which ways you are terrible because you've broken this thing out there. And then the argument becomes about whether the thing is real or not and who's right about the thing. Whereas if you personalize it, which is much more vulnerable, you talk about what you need in that situation. What is it you need? So you're taking responsibility for your feelings because you're saying, I feel this because I have a need to feel supported, or I have a need to feel that you're going to be reliable if you make a promise. It's about me and my needs. And I think the really powerful thing about the language of needs is that they are truly universal. Everybody has needs. And when you drill underneath the sort of basic level needs and you keep drilling deeper and deeper, you end up with very basic needs that both parties, whether in a commercial transaction or in a personal relationship, have. Is a need for respect, a need for community, a need for connection, a need for the very basic human needs that we can all share. And when you get to that level in the conversation, you then can, at that point, you can start thinking about, okay, well, what's the request that I'm making? The difference between a request and a demand is that the other side is able to say no. If they're not allowed to say no, it's a demand, it's not a request. No doesn't have to be the end of the conversation, because then you can have a conversation about their needs. What sits behind that no? What is it that they feel about what you're asking? So it's a much deeper conversation, and it's a conversation that goes much deeper than the surface. But the thing to notice about an MVC conversation is that requests come right at the end. And the requests only work when you've done both the personal reflection and the communication. There's a lot of self-knowledge that comes with being able to actually identify and express needs. And if you haven't done that work, if you stay at the surface of, gosh, I feel a bad feeling, therefore you must be at fault, and you just deflect immediately, you never get to that self-knowledge and being able to share that with someone else. And then when we come to talk about compromise normally in disputes, we're talking about compromises of demands that stayed at the surface. So we haven't actually done any of this digging work. We haven't worked out what it is we really need. We haven't made requests based on our needs. We just stay stuck in positions, and then we try to compromise. And actually, compromise in that context becomes potentially a negative thing, because you're both feeling resentful, no one's needs have been met, you actually haven't made very much progress, but you think you have because you made a compromise. So that's just a little bit of context there on MVC. I'll bring all the strands together, and hopefully you'll see why this is relevant to mediation further down the line. But this is just a general tool, I think, for relationship, and it applies really in every context. We can, in the discussion phase, we can talk about how it might apply and some examples. So some needs. This is called the needs inventory, and it comes from cnvc.org. So NVC is a very popular concept. There are training courses on it. You know, it's not something that, because it's a skill, you can actually go away and learn MVC and become skilled at these sorts of conversations. And they include an inventory of needs. I think, like feelings, we don't tend to have the vocabulary to talk about our feelings or our needs. And then it becomes very difficult to have a conversation in which you tell people what you need, because you don't actually know what you need. So I spent time in my training actually just trying to learn words for different feelings and trying to learn words for different needs. Because sometimes if a third party is able to help you articulate that, are you feeling this? Are you perhaps needing that? You go, oh, okay, yes, that really helps to clarify what's going on for me here. And often in a conflict situation, people are needing acknowledgement. You know, really basic things. They're fighting about the $5 million, but what they're really needing is acknowledgement that they were wronged. What they're really needing is respect. What they're really needing is reliability when their business partner promised to do something. So they're needing something much deeper than the subject matter of the dispute. So I was talking about the different layers in an argument, and to kind of use domestic arguments that you're often told if you have a repeat argument a lot at home, you're not actually arguing about the thing you're arguing about. You're normally arguing about something completely different. If you keep arguing about the dishes, what you're really arguing about is feeling supported or feeling cared for. If you keep arguing about money, what you're really arguing about is stability and safety, perhaps. So there's often something deeper beneath the surface. And it's not that different in a legal dispute. In a legal dispute, you have the stated positions. So people write each other letters before action, and they say, you owe me this much money. And the other side says, no, you're wrong. You breached the contract. You owe me a different amount of money. So we have our stated positions, and they sit at the tip of the iceberg. And then, you're all familiar with the iceberg metaphor. We use it for kids. When you see a tantrum, there's actually lots going on underneath the tip of the iceberg. So you've got your claims, your demands, your solutions, your rights. That's what we write to each other about. People don't get vulnerable in pre-action correspondence. What they do is they take positions and they instruct solicitors who write very aggressive letters. And what's going on underneath the surface is there are needs, there are concerns, there might be health issues, there might be emotions, there might be financial pressures, there might be fears and hopes, there might be feelings again, so emotions and feelings, history, there might be a need for speed, there might be reputational and other risks. So in a joint venture dispute, for example, often those disputes are very hard to resolve because the venture partners were friends, or they may have been family members. And so what sits under that basic commercial dispute is families that are torn by this dispute, you know, spouses who might be saying, if I hear about this one more time, I'm out. I've had enough. Because disputes that run for years and years have a devastating impact on the family. There might be financial ruin at stake because you keep dishing out legal fees, and you just don't know how to stop. You don't know how to put an end to a spiraling dispute. There might be health issues. So the dispute itself might be having an impact on your health, or there might be completely unrelated health issues. And obviously, when you're speaking to the other side in the dispute, you're not going to communicate that. You're not going to give away any weaknesses. So you keep saying, well, no, you owe me the money. And they say, no, you owe us something else. And it runs for years. And believe me, when I say it runs for years, I'm in one large piece of commercial litigation that I got instructed in 2018, and we are in the Chancery Division in trial in June 2024. And that's how long it has been going. And it hasn't been busy all of that time, so it kind of comes and stops for various reasons. It got stayed for various reasons. But legal disputes, even when they're not that protracted, can still run on for a number of years. And that whole time, every time your solicitor writes a letter to the other side, you know, they are billing by the minutes, and the other side then send a long, angry response back, and then you feel you need to retaliate, and so on and so forth. So this is where mediation comes in, because, and I really like this quotation from Bill Marsh, who's a great mediator. He says, mediators are bearers of hope and agents of reality. Hope because you have to trust the process. And it's very difficult to trust the process. People who have been in a dispute for any length of time then have experienced a breakdown of trust with the other person that they're in a dispute with. And it's very difficult to believe that a process can lead to decent behavior. And the number of times I've had that conversation with people where, I mean, I'm not a family lawyer, I'm not a family barrister, and I have no family law experience. But because I'm a litigator, people will call me for advice and say, oh, you know, this has happened and I'm in this dispute. So I almost always say, okay, have you thought about mediation? And the response will be, oh, no, you don't know what he's like, or you don't know what's happened. Or, you know, there is just no way this is going to work in my context. And I say, look, it's just today, and just try to trust the process. And the reason I'm here is to try to explain why the process might work. So I'm not just telling you to blindly trust the process should you need it. But there is something in process that offers hope that might otherwise not be available to the parties. And I say agents of reality because, again, having an impartial party who can talk to you about the elements that sit underneath the waterline. Not entirely sure what's happening. So the power of mediation is that hopefully, if I'm able to establish trust with both sides, they will both start talking to me about those things underneath the waterline. Right? They will only talk to each other about the things above the waterline because they can't lose face and they're not prepared to show weakness. But they might start talking to me about, look, my wife said if I don't sort this out today, she's done. She's had enough. And that's how damaging a legal dispute can be. They might start talking about their financial constraints. They might start talking about the other business interests that are impacted by legal dispute. So that's where the agents of hope comes in. But dealers of hope. The agents of reality comes in when, you know, your solicitor, perhaps even your barrister, has been on your side for so long that they might not push back as much as a neutral party who's heard from both sides and is able to see a slightly more nuanced picture and is therefore able to say, okay, I hear you, but if the other person is not good for the money, what's the point of winning this case? What happens next? So, for example, I had a mediation where one side did really have better legal merits. I could see that, you know, they had a better legal case, and there was a huge amount of ego involved as well. But you could say to them, okay, so you win and you get a judgment, and then what? What are you going to enforce against? Okay, this person has no assets in the UK. So what are you going to do with that judgment? And you're trying to get them to work past, though, what's actually in your best interest, not just, you know, what is the ego driving towards, what's that kind of slightly empty win going to achieve, but what's really in your interest. Once you get that empty victory, then what? You know, what if they can't even meet your costs? So you've paid hundreds of thousands of pounds to your lawyers, and you've got this victory, you've got this judgment. What are you going to do? Hang it up somewhere and say, this is it, this is what I've achieved. And so you're able to have this process where this neutral party that hopefully you've built some trust with, who knows, you have to keep reassuring them that you're giving the other side an equally hard time. So, you know, once they start thinking, you know, you're only picking on them, it doesn't go well, that you're then able to get past those positions that were stated at the outset and start thinking, okay, what do we really need here? What is it that you want? And it always surprises me how people are able to move through the process. Like when you start in the morning, you think, my God, we're not going to make it any, you know, these people hate each other so much, I can't even put them in the same room. Because normally you'd have a plenary discussion where everybody comes together and you kind of say, this is what we hope to get today. And sometimes the parties are so angry with each other, you can't put them in the same room, you keep them apart. But somehow, once they've been through the process, when they talk about how they feel, and they talk about how wrong that they've been, and they get listened to, they start emotionally moving through that and start moving towards, okay, where could we go from here? And I've been wondering about how that works. Recently, I did some training, not in a mediation context, but I think it's actually really powerfully applicable in mediation. So this comes from David Rock, who wrote a book called Quiet Leadership, which I highly recommend. It's really interesting. And it's about leadership techniques that are based on neuroscience and how people respond well and how they don't respond well to certain things. One of the things he talks about is this idea of our brain being in a threat state or in a towards state. So when you're if you're in a sufficient sort of threat state, you're unable to think collaboratively, or unable to think creatively. We know all the things that we hear about fight or flight, you know, people shut down and they're not able to think in the same way. In a towards state, you're more creative, you're more collaborative. So how do we get people in that towards state rather than that away state? And this is his CARF model. So he says there's 5 components, which if they're positively impacted, move you towards a towards state. And if they're negatively impacted, they move you towards an away state. And these are status, certainty, autonomy, relatedness, and fairness. And I think every single one of those is impacted in a mediation situation versus a litigation situation. In terms of status, I mean, you're an equal in a mediation. It doesn't matter how powerful the other side are. You get equal respect from the mediator, you get equal time from the mediator, and you're given that heightened status, if you like, which helps you to feel respected and listened to. And I think that helps people move away from being so negative and confrontational to starting to think collaboratively about solutions. You've got certainty because you can walk away at the end of just a one-day mediation with a resolution. In situations where litigation could go on not only for months until you get to trial, but you might end up with a reserved judgment where the judge goes away to think about the judgment. And then you have absolutely no idea what they're going to decide, right? They are the decision maker, not you. You have autonomy, relatedly to certainty, because you decide the terms of your agreement. So a mediation is not binding until the parties have signed a mediation agreement. So they know what goes into the mediation agreement because they negotiated it and they agreed it and they wrote it down and they signed it. So they have certainty and autonomy over the terms of their agreement. Relatedness, often in a mediation, we're able to get people eventually around the table where one person apologizes to the other, and you might actually be able to start healing a relationship, even if not quite, back to where you were before. But there are times when people do walk away thinking, well, we might have a relationship in the future. Whereas in litigation, having put them on the stand and cross-examined them and accused them of lying and God knows what, with then a public judgment to follow with all of that spat for everybody to read, you have, by all means, burnt every bridge possible between the two of you. And again, fairness. So a mediator who handles the process well ought to give both parties a sense that they are being handled fairly. So all of those 5 elements, I think, mean that neuroscience can help us understand why mediations have such a high success rate, relatively speaking. Not necessarily my mediations, by the way. My clients don't seem to like settling. That's a different issue. So I think it's so powerful to start thinking about moving away, whether it's, and I found this charity recently, I've included it in the resources in a moment, I'll come to it in a moment, where you think about all the disputes that we are surrounded by, whether, as I said, community, family, spouses, legal disputes, that if we are able to find better ways to speak to each other, if we've got the skill level, if we can build the trust, then that's an excellent starting point. But if there has been a breakdown of trust where we're unable to reach each other anymore, how the power in being able to find a neutral person and place them in the middle so that both parties start turning towards each other by turning towards that person sitting in the middle. And how powerful it is that somebody, even if those parties never hear it, it's one of the things I'll come to in a moment, is confidentiality. And so much of mediation is possible because the conversations are confidential. But at least there is a party involved in the disputes that gets to hear some of the material that's under the surface. And normally you'll come all the way to the end of the dispute and nobody on the other side has ever heard it, right? You're not going to tell the judge, you're not going to tell the other side's solicitor. And so what you do is you fill the gaps with stuff you make up, really. There's just a complete lack of knowledge about what's going on the other side. And as I said, I've seen this as a litigator all the time. Why have they sent us this letter? What do you think is going on here? And we just start making up what we think their position is and what's going on for them. And you never make up a friendly story. Like, you have to make up a story that involves them being, terrible people. So you end up escalating conflict. You end up in this zero-sum game where a judge decides one winner and one loser. And the loser not only doesn't get the thing they were asking for, but they have to pay the other side's costs. They have to meet their own costs. And you never get to hear about all the other things that were going on that could have been the answer to this dispute had you heard about them. I've got a table here. Where have I got this from? I don't know, something. Parents and pediatricians. Well, there you go. That's one scope for mediation. So there's conflicts between parents and pediatricians, and they've set out here a comparison between litigation and mediation. As I said, mediation is consensual, and that goes to the autonomy piece. You don't even have to stay until the end of the day, and that's something we say to the clients right from the start. It tends to work really well, actually. So if I have someone who seems offended by the idea that I'm disagreeing with them or sort of challenging them, I say, well, actually, the beauty of this process is you don't have to stay. If you don't like it, you are free to call an end to the day and to just leave. But you don't have that power before a judge. So you might want to hear from me about how this process might go. And they will almost always say, okay, go on then, and then we can have that conversation. But because they've got that autonomy to decide whether they want to be part of the conversation or not, they may be much more willing to be constructive and open. It's inexpensive. So even if the rates are expensive for the day, in relative terms, it's much cheaper than having a long-running dispute. It's confidential. So it's confidential both in terms of the conversation you have with me as the mediator remains confidential unless you give me permission to pass some things over to the other side. But you might say for the whole day, you're not allowed to tell them anything I tell you, other than the offer amount. You can take that over, obviously, because otherwise it's pointless. But you're not allowed to share anything I tell you. Even then, it's helpful for me to hear your side of the story, because then I can ask them certain questions that otherwise I wouldn't know to ask. And it also remains confidential as an overall process. So if the whole thing breaks down, any admissions you make, anything you share, isn't allowed to be shared in court. It's completely without prejudice to the legal process. So everything stays confidential. It's a mutually agreed solution. And I've talked about the sort of negatives you might be able to avoid by mediating rather than having a legal litigation, resolving your dispute in court. But I haven't touched on the positives that are not just about avoiding negatives. So a mediated agreement can be much broader than something you can achieve in court. What we often see is you can tag on things like, okay, well, if you can't pay me, you can perform these services for me instead. That's not something a judge can order, right? A judge can only order the judgment sum to be paid. And if it can't be paid, then you have a new legal dispute trying to enforce the judgment. But in a mediation, you can agree non-monetary things. You can say, well, you run an IT business, but currently you don't have the money to pay me. Well, I have these IT needs, so perhaps you can do this for me instead. And so sometimes, in fact, people enter a mediation because they've got a very lucrative ongoing business relationship that they want to maintain. They're having a dispute about one thing, but they've got another thing that is going very well, and they don't want to destroy that. And so you build all of that into the resolution. So you say, okay, but we keep doing this, and maybe we could do a bit more of this other thing. So it can be much more creative, much more expansive, whereas judges are much more limited in the remedies they can order. And they certainly can't start offering services and other things. Timescale, as I said, you can decide to resolve it within a day. We see now much more frequently that people won't stay late on the day. They'll just sort of say, well, let's just leave it for today. And most mediations are actually resolving within a couple of weeks of the mediation day, whereas in the past, people would just keep going well into the night to try to resolve it. Perhaps a disadvantage is that it's less regulated, so you might get more of a mix in terms of quality of mediators. And at the end of the day, there might not be resolution in mediation. So whereas in the court judgment, you'll always end up with finality, you won't necessarily get that in a mediation. I think that's it. Yeah, so I've shared just a couple of resources. So COED run a mediation service. I think it's been much more proactive in the sort of family space. I'm one of their volunteer commercial mediators through COED, but I don't know how proactive that part of the scheme has been. Wandsworth Mediation Service is very good. So they run, their panel has high-end commercial mediators who are normally charged out at many thousands, and they do those for lower rates as part of that service. Calm Mediation, in fact, trains young people to mediate within schools and universities, as well as offering family and community mediation. So it's a really exciting initiative. And as I was saying, if you can imagine that if in all of our spaces we had people who were skilled to facilitate conversations, to facilitate that better relationship, that a conflict is, a request for a better relationship. If we had people facilitating children at school learning how to facilitate those kinds of conversations and then carrying that through into the workplace, into to their communities later on, that would be wonderful. And then I've just included ACAS there. I'm not a workplace mediator, but I think workplace is a prime example of a place where you might have a dispute, but you need the relationship to survive the dispute. And so they've got some information there about mediation. So thank you very much for listening. And I was hoping we would open it up and sort of have a discussion. So please do raise anything.
Any questions from anyone?
Assalamu alaikum. Thank you so much for this. A couple of very quick questions and short answers, hopefully. So, first question: Does a mediator necessarily have to have a legal background? Okay. Number two, is there an umbrella organization of mediators, and what numbers are we talking about nationally? How new is this profession, so to speak?
So it's, I don't think there's an umbrella organisation. There are definitely some organisations, there's a number of them. So I'm registered with the Civil Mediation Council, which is one of the well-known governing bodies, if you like. So they'll have some standards around code of conduct and ethics. There's various different organisations that offer the training. So I've trained with CEDA, but there are others that do the training. CEDA itself is registered with the CMC as a training organisation. You definitely don't need to be a lawyer to be a mediator. I mean, in the context of complex commercial disputes, people like to be talking to a lawyer so that, because they like to involve you in the merits. Often the merits of the disputes aren't really what we're talking about, and that's what we try to get them to see. It doesn't really matter who's right about the law and who isn't, because of all the lists of interest that I was talking about, they end up trumping on the day anyway. But because they want you to sort of sit in the quasi-judicial role, at least at the start of the day, and kind of tell them, oh yes, I see the strength of your case, they tend to like lawyers. But the people who trained me, so I got trained by a former police officer who was a very effective negotiator, because he used to negotiate hostage situations, as well as sort of suicide situations and like threatened suicide situations. And the other lady also wasn't a legally trained person, and they were both very effective and have very successful mediation practice. And then the other question you asked, how old is it? So I recently co-mediated a dispute with someone in my chambers who's been working exclusively, I think, as a mediator for about 20 years now. So it certainly isn't new. I think sort of the number of younger mediators is probably growing. And there's also a growing conversation in the legal system about what stage mediation should come in. So there's currently a consultation in the Ministry of Justice around compulsory mediation for small disputes, and whether people should be forced to mediate or not. So some of those conversations are quite new.
So
but
I think you answered my last question.
Yeah.
So the client or the defendant don't necessarily go to a mediator. They would normally go down the legal route, and hopefully the legal advisor would suggest to them,
Yeah.
go down the mediation route first.
So I think it depends. It really depends on the situation and people's level of knowledge about mediation. I think that's why it's important to have these community discussions, because mediation is not very well known. The problem with relying on legal advisors to recommend mediation is there's a conflict of interest somewhat for sort of the legal advisors to say, why don't we resolve this quickly and cheaply rather than dragging on for a few years. So different legal advisors have different attitudes to mediation. There's ones where, you know, some disputes just are really crying out for mediation, because there are rights and wrongs on both sides, and you think, well, there's got to be a commercial sum of money we can agree on here, and we'll go home. You know, this is silly. But that's very much an attitude. So I found myself as a barrister constantly feeling frustrated, like, why are we fighting this? This is ridiculous. But I didn't have access to the other side. I can only say that to my client, and I don't know what the other side's barrister is saying to them or their solicitor is saying to them. So I thought, I need to be in the middle. So I can say to both parties, what in the world are we doing here? This is ridiculous. So there's a lot of attitudes involved. I think if you have the awareness around mediation, I still think you need legal advice. I didn't go into that, but we can have a conversation about what makes an effective mediation. And I think one of the things that makes for an effective mediation is knowing where you stand. So actually just knowing, without communicating it to the other side, knowing the strengths and weaknesses of your case. You know, what's your best case scenario? What's your worst case scenario? And having a sense of that. Mediator is not there to provide legal advice. So I wouldn't be providing legal advice to either side. I might push both cases and kind of ask some questions, but I'm not going to be saying, these are the merits of your case. That's just not my role. So if you didn't have a lawyer on your side that you could turn around to and say, what about this? What do you think of that? You might then not be able to engage with the process with the same amount of confidence about, is this a fair settlement? Did I get cheated here? Am I happy with? And so I think it always makes sense, if you have a legal dispute, to go and speak to someone about the merits of your dispute. You know, what are the prospects of success? If you succeed, how much would you recover? What are the likely costs? That gives you the basic information you need to then be able to engage in a negotiation and reach a settlement.
I'll just add one more. Early Islamic history,
Yeah.
early Islamic years, is there evidence of this exercise?
I haven't investigated, but I wouldn't be surprised, to be honest. You know, that sort of, I think not just in early Islamic years, but even in other legal cultures, you know, that sort of tribal elder that people go to who mediates disputes between people, it's not uncommon.
Zahra?
You've touched on most of my questions there, to be honest, but a few more. So when people come to an agreement, do they waive the right to take further legal action? Okay.
Yeah, so the idea of the agreement is that it's in full and final settlement of that legal dispute. What you're not waiving is your right to then sue on that agreement. Okay, and then you might think, well, what have I achieved in that case if I'm back in a legal dispute? What you've achieved in that case is there's no longer uncertainty about what you're entitled to because you've agreed it and it's written down and it's signed. So to use the example of the case where you might not be able to enforce, for example, you think, okay, well, what's the point of a legal settlement if the other side might not pay? At least now you're not spending all that money to get the judgment because you've got your legal agreement that says they've agreed to pay you whatever sum of money, and then you're straight into the enforcement phase, whereas before you had all the risk of not being able to get the judgment in the first place.
Okay, so a question related to that
Okay.
is mediation clearly fills a gap, right? Like you say, someone might not have assets on paper, but they have other valuable things that you might want. Do you see, seeing as lawyers have a conflict of interest, and it's an industry in its own right?
Yeah.
I'm an actuary, so I understand the creation of that. Do you see it coming into legislation to protect citizens in certain scenarios where mediation might have a better outcome, to attempt mediation for a certain period of time before litigation can be pursued? Or are there examples of that in other countries?
So do you mean the idea of mediation being compulsory?
Yeah, or like at least attempted before litigation.
Yeah.
Is...
So I think that already happens in certain spheres. So I think in family context, for example, sometimes judges order you to go away and mediate. I know it's normally an option, but sometimes in a particular case, you might be ordered to go away and mediate. As I said, there's a consultation at the moment now in the Ministry of Justice about small claims being forced into a sort of compulsory mediation phase. But the bottom line about mediation is they can't force the outcome. They can only force you into the process, which arguably sort of robs it of some of its merit. Because if you're not there by choice, then all of those advantages I was talking about earlier about, you know, autonomy and choice are taken away from you. I remember listening to this podcast by a mediator who was saying, you know, I tell people in the morning, if they're there on a compulsory mediation, so if the judge has ordered the mediation, I tell them in the morning, you're here, so you've done the thing that the judge has asked you to do, but you're now free to leave. Because unless you give them that choice to leave,
that buy-in.
You won't get the buy-in you need for the sort of the creativity and the collaboration you need to actually get anywhere. So she just tells them you're free to go now. But, you know, since you're here, and they'll always stay, you know, even when they hear something from the other side that makes them angry, there's always a moment, not always, but there's often a moment in the mediation where the other side has essentially made an insulting offer. And you kind of talk to them and you say, look, I don't think this is a good idea. And they say, no, this is it. This is my offer. I would like you to go and communicate. And I say, okay, this is exactly how it's going to play out. And then I know, I stand by this. This is my offer. You go to the other side and you tell them the offer and they grab their coat and it's a complete waste of my time. And they get angry and you just ride that wave. And they're free to leave. They're always free to leave. But then they just sit down and say, okay, let's talk about this. And it's that, it's that freedom to go, but in the knowledge that if you stay, you might be able to finally resolve this thing and wake up the next day without that dispute hanging over you that people find so powerful, I think. So, I mean, I said the conflict of interest point as a joke. I'd like to think anyway, that as, regulated professionals, if we genuinely thought it was in our client's better interest, that we would actually mediate. But it's just that people's attitudes are impacted ultimately by kind of unrecognized conflicts, I think, of interest. So, I'm not suggesting that solicitors are aware that this is not good for my client, I'm going to do it anyway. They genuinely, and that's the problem actually. Often in a mediation, the most obstructive people are the lawyers, and we try to get rid of them or kind of quieten them down at the start. But because they've genuinely been fighting their client's case for so long, they believe in the merits of it. They believe if they take it to court, they'll get certain things, and so you have to actually just sort of quieten them down for a bit and say, okay, can we talk to your client and figure out what they need, not what you need in that moment. So I do actually believe it to be genuine, but it's just not necessarily helpful. It's not the right perspective.
Okay. Assalamu alaikum, sister. Thank you very much. It was a very nice subject. But as I am a Muslim and I live in this country, and there is a lot of Muslims living in different countries. But the subject for mediation, as you mentioned, is for people non-Muslim. As a Muslim, for myself, I think for my brother, when he asked the question, if the Islam has provided something for me, yes, there is. There is further رسالة الحقوق الإمام زين العابدين عليه السلام. Does show the right for a child, for women, it's very nice letter of حقوق. We call it letter of right, رسالة الحقوق. It does actually give the right for every human body, even the nature, even the animal, everything. They have the right. But we need someone to know, to have education about all this right. If we know our right in educational way, so I think the dispute in mediation will be easier. In the role of ulama in the Sharia, for our community is very important to apply, because we started our program for the verses of Ayat Quran showing, and there is something being done. And that's on the question is, or our community needs educational knowledge about our rights for every member of the family, in the business and everywhere, as the people living as a non-Muslim in other country. Do you think we need for the mediation?
So I think we do for a number of reasons. The first one is our disputes are not limited to disputes with members of the Muslim community. So that's the sort of most obvious point, right? You're going to be having employment disputes at work, and you're going to be having other disputes in other contexts where there's not going to be that common ground. But I think even in a sphere where you have the common ground, I don't think legal rules resolve as much as we believe them to resolve. And I think that's because of the thing I was saying earlier about, what are the different needs that we're talking about. If we don't have the process to be able to do that digging into what are the two perspectives we're coming to this conversation with, what is this disagreement really about? You don't even get to the stage of, okay, which of the rules is, we can agree as part of a mediation that we're going to try to apply a particular set of rules or ethics, and they don't have to be English law. They can be whatever we want them to be. So we can say we will take inspiration from Risalat al-Huquq, we will take inspiration from whatever it is we want to take inspiration from. And as I said, the mediator is not imposing a resolution. mediators just driving a process, they're just driving a conversation. The problem I see within our community with the sort of, they are essentially attempts at mediation when an alim gets involved or a Sayyid gets involved. The problem ultimately comes to enforcement. Because at the end of the day, you have a sort of agreement of sorts that both parties have entered into. Not necessarily following as rigorous a process as you would like, where you try to dig in deeper into, what's going on here, what are the interests, what are the needs. But you have an agreement at the end of the day, and there's no means of enforcing it. There just isn't. There's sort of social shaming, potentially. Beyond that, you don't really have anything. And I think that's why mediation tends to be effective, because litigation exists, right? A conciliatory solution is effective because if it fails, there is a fail-safe, which is a litigation process where you can go to a court and you can say, this person signed this agreement with me and they are failing to deliver. And if you don't have that enforcement mechanism, you don't have very much when you agree. I mean, you might be able to resolve some disputes, many disputes. People might be able to reconcile and therefore not need that enforcement. But I think ultimately some level of enforcement is necessary. And that's one of the things we really lack, I think, as a community, is some sort of enforcement mechanism, because people agree all sorts of things and then they don't abide by them. And you hear that all the time, whether it's a custody arrangement, whether it's a sort of financial support arrangement. They go to the Sayyid dishes out the Islamic law. Yeah, so I think what you're proposing is something we refer to as arbitration rather than mediation. So essentially, the judge decides. Yeah. So the Islamic judge decides, and then does nothing about enforcement. So something about enforcement in the hereafter, but in this dunya, you take your Sayyid given judgment and you do what with it exactly. I mean, it's an interesting philosophical debate. I'm obviously a lawyer, so I've bought into the idea of the rule of law, man-made law, and that it has benefits, and that I don't see it in any way as being consistent with Islam, actually. But I think the overriding benefit of man-made law is that it has an enforcement mechanism that actually works, which...
Thanks very much for a very interesting talk. It sounds like for certainly low-level conflict, you actually don't need a mediator at all. You just need two parties that are slightly emotionally aware. Would you agree?
I think in many conflicts you don't need a mediator. So in fact, even in very high-level conflicts, sometimes solicitors are able to negotiate a solution without a mediator. It's actually regardless of the amount of money involved, whether people are able to have the conversation or not, is whether you need the mediator. So do you need an impartial middle person in the context of a conversation? And sometimes you need that much more, even if there's no money involved. So it might be a co-parenting dispute, it might be a child custody dispute. So there's no money at stake. But there's such a breakdown of trust between the parties that unless they bring someone in the middle, they're just not going to be able to reach a resolution. So I don't think it necessarily is a question of money. But when they're purely financial disputes, obviously the less that is at stake, the less people get hung up about whether they just walk away or whether they settle for less or whether they settle for more. If hundreds of millions of pounds at stake, then everything becomes much more high stake. And you want to know that you fought as hard as you could. But if you're talking about a couple of £100, you might agree it, you might just walk away and think, actually, this isn't even worth my hassle. So I don't think it's I think there's definitely truth in that, but it's not just about the money.
Awesome.
Assalamu alaikum.
Walaikum assalam.
Thank you for your talk. Do I understand correctly that when you're mediating, and if lawyers are involved or whether they are or not, are you almost, although you're not a judge, but are you presented with the cases, formally, so that you can understand what's going on before you kind of talk to them? Is that
So
how it works?
Yeah, so you normally get a mediation statement from both sides, which is a short document setting out their position, where they say they stuck with the above the waterline points, where they say this is our position, these are the rights and the wrongs of this case, and both sides will share that with each other, so they both know what I've seen. And they might send me a bundle of documents that sits underneath that. So a couple of ring binders of the key documents that sit underneath that. Because it is important that I have some sense of what the legal dispute is about.
Otherwise, it'll take longer than a day to kind of resolve this stuff. But the reason for the question is just to understand better and to get to the kind of one of the key questions is that, and I suppose because there's an enforcement and there is kind of legal binding documents, I suppose, that people sign at the end, I assume the whole process is documented. In effect, it's minuted. So how do you get to make sure that there's no misinterpretation, misunderstanding? Is it simply right at the end?
Try to be as clear as possible in your agreement. So there's absolutely no minuting, and I mean I might write a few things down for myself. Normally, if I'm given permission to take something over to the other side, so if they say, okay, you can share this particular point when I'm going over to the other, so put people in separate rooms. There's normally a joint plenary room, so there'll be one room in which everybody can sit if that's conducive. As I said, sometimes things are so heated that it's not. I will normally write down the exact thing I will say so that I don't say the wrong thing. So only when I'm sort of given permission, I'll say, okay, so you want me to say this to them, and I'll write it down. But I won't write much else down, and that helps with kind of preserving confidentiality as well. But in the end, you're boiling it down to heads of agreement, like just the contract, it's a legal contract. So,
which you have to draft.
Yeah. So normally, I mean, that's why I was saying it is actually helpful to have solicitor support. You want the parties to have their own lawyers there, and in a big, serious commercial dispute, the lawyers are going to be poring over that agreement and sort of, and that might not be signed on the same day. So they might sign heads of agreement that day and say, okay, here are the key points we're resolving. So in a recent case, for example, I then had another half-day mediation put in the diary for 2 weeks later. And they said, we're now going to negotiate this agreement. And if we get stuck, we might need that half-day with you. But if we don't, then we'll just cancel it. And so, they've both got serious legal advisors, and it's just going to be boiled down to a contract that's then signed between them that says, you pay this on this day, we then release this thing. And, these are the, exactly.
But you said that doesn't stop anybody from litigating, right? From litigating.
Yeah, no, it does. It's supposed to stop.
It's supposed to stop.
So it's a full and final settlement of that dispute, and then you're stopped from litigating. What doesn't stop you from litigating is they then don't pay by this date.
Oh, I see. So they break the agreement.
You don't restart the whole dispute. You just sue on that contract. So that legal agreement then becomes something you can sue on. So you say, they promised to pay me on this date and they haven't. And you just have a simple money judgment. You then don't need to reopen the whole background again.
Understood. Just on one thing, you mentioned that you don't need to be a lawyer in a sense, but would you, if you came across a case where you're mediating, you found some element of criminality, if you're not a lawyer, how do you know that is an offence that's been created? Or if you do know, can you continue to mediate?
I have no idea, is the honest answer. It's not something I've come across. I mean, part of my CMC registration is that I've got access to more senior mediators that I can speak to. So I've got some really kind colleagues that I'll normally contact and say, oh, I have a mediation next week, and they say, you know, call me if you need anything. So I think in that very unexpected context, I might pick up the phone to someone and say, you know, what should I do? I mean, often as a lawyer, even as a barrister, you know, if there's a situation that is contrary to my ethics, for whatever reason, you know, if a party is saying, I want you to plead this, but it's not true, or I want you to say this to the judge and I know it's not true, or there's something criminal going on, I would resign. So that, you know, I'd expect that a mediator would be in that context as well. What I don't know is then, do you have any obligations to report anything or anything like that? And normally confidentiality does protect these things unless someone's at risk, or, you know, that there's something that trumps your duties of confidentiality. But you're not, you know, you don't normally sort of then take your paper as a mediator and submit them to the authorities. That wouldn't sort of be contrary to the trust you're trying to build. Yeah.
Thank you very much. I know there are a couple of questions, but inshallah you can ask them afterwards, so we'll have to end there, if that's okay. Salawat ala Muhammad wa ala Muhammad. Just a quick announcement. Next week we have Nada Al-Hudayd, who will be speaking to us about Shia religious art in the Arab world and beyond. And tomorrow there is an event, but if you haven't got an email about it, you're not invited. If you'd like to find out more about any of our programs, look at sikkim.org.uk. Salat ala Muhammad wa ala Muhammad.